Good afternoon. Thank you for everyone that's attending our webinar this afternoon on employment practices liability. We're going to get started momentarily here, but I just want to take a minute to let everybody know that you can ask questions during the middle of the webinar by just hopping in the chat and place your question in there. We've got folks monitoring the webinar as well, and I've also got my chat open, so hopefully we'll see your question and answer it. And of course, if we don't get to your question, you can always reach out to me directly after the webinar. So with that, I'm going to get going so I can honor everybody's time. Again, our webinar today is on employment practices liability. This is something that all the right-at-home agencies are required to carry. And I know a lot of you guys kind of wonder sometimes what it is you're carrying and why you're carrying it. So I thought this might be helpful to you guys and help you to understand and also make you aware of the risks. So, and I'm going to go ahead and before I get into this, I'm going to say that some of this is, I guess, legal and reading type stuff. And I hate to do it, but a part of the way we can present this, the only way is to kind of go through some of it. I'll try not to go too much into it, but at the same time, we got to make it beneficial. So, so all employers, are subject to the laws of that affect employment practices liability, and so anytime you hire somebody, you're going to be subject to employment practices lawsuits. And every day you're working with employees on hiring, compensation, promotions, and accommodating disabilities, terminations, and more. Any of that stuff can lead to a wrongful employment practices liability claim. And quite honestly, employment practices liability claims and issues occur daily. And it's not just the settlements. The settlements happen, but they're not nearly as common as the defense costs. And the defense costs really are typically about 60 to 70% of every employment practices liability claim. So it's not just, it's really not mostly the settlements. It's mostly defense costs. Defense costs, even if it's just an alleged claim, defense costs begin to accrue. And I don't know if anybody's hired an attorney lately, but they make a pretty decent hourly fee. So those defense costs are probably the biggest thing that you're going to face in employment practices liability claim. Again, there's all kind of main things that you look at when you're talking about employment practices liability is wrongful termination, harassment, breach of contract, discrimination. Everybody knows about discrimination and harassment, retaliation. And in these kinds of incidents and claims, you're typically dealing with a state or federal agency like an Equal Employment Opportunity Commission, Department of Labor, Americans with Disabilities Act, or the Family Medical Leave Act. Any of those laws can bring employment practices violations and claims into focus. And so, it's taken extremely serious by any of these state or federal agencies. And again, we see these all the time, but most of the expense comes from defense because the courts always kind of lean toward the side of the employee. So we've got to make sure to protect your organization as best as possible. What is an employment practices wrongful act? Again, it's a good bit of reading here, but wrongful act means any actual, and you see the word alleged, error, misstatement, misleading statement, act, omission, neglect, or breach of duty committed for, and look how broad that is. Any. That in insurance, that's a word we always get weary of when it says any. Those are words that means there's a lot of liability. Wrongful discharge, dismissal, termination of employment, including constructive discharge. Anything to do with a wrongful termination. Any breach of oral duty, implied employment contract, quasi-employment contract. Doesn't it sound like an official, a politician is trying to cover anything that could possibly happen, other than a labor agreements or arbitration, any kind of proceeding pursuant to a collective bargaining agreement, employment related misinterpretation, violation of any federal, state, or local law that concerns employment discrimination, including sexual harassment, uh, workplace bullying, that are made as a condition of employment, and used as a basis for employment, or create a work environment that is intimidating, offensive, hostile, or interferes with performance. Hostile work environment is one of the bigger types of claims we see, and they continue to grow. In fact, that doesn't necessarily mean it has to come from somebody you work with or one of the employees of your business. It could come from somebody that just comes into your office or your place of business, and maybe they're a FedEx guy or something. I mean, it's incredible. It really all comes down to how the attorney structures his complaint, and it just depends on, can they make that bridge, I guess, if you will, to the to make it a loss, I guess a claim that can be arbitrated. And so it's an amazing thing, but it doesn't really matter what the policy actually says or what actually happened. But if there's a way for them to bring the claim so that it can be arbitrated, it happens, and happens all the time. Continuing with employment practices liability, what is it? Wrongful failure to employ or promote. It's not just terminating if you fail to promote it. Wrongful demotion, wrongful discipline, wrongful deprivation of career opportunity. Notice every one of these say wrongful. There has to be a situation that shows that you didn't do something intentionally. It's a different kind of thing compared to a lot of insurance, but there's got to be an intentional neglect to promote or discipline or failure to promote. Negligent hiring, which means basically you're just hiring somebody without a background check, or even if you hire a background check and they have some concerns on there that you don't address them, you go ahead and hire them anyway. Negligent evaluation, employment related personal injury. Right there, I always think about defamation of character. If somebody does something to give you a bad reputation and basically where you can't get a job, that's going to be an employment related personal injury. Wrongful failure to grant tenure, employment related wrongful infliction of emotional distress, and violation of the Family Medical Leave Act. We've talked about a lot of legal and things like that. Has anybody got any questions? If you do, please pop them in the chat. Okay. I don't see any yet. If you do have a question, please let us know. We're going to slide number 6. Wrongful retaliation. Of course, it means getting back at your employee for making a claim, and it happens all the time. Wrongful denial of training, denial or deprivation of seniority or evaluation, failure to adopt or create or provide or enforce adequate workplace for employment practices and procedures, or wrongful handling of any background check. If you don't follow through on the details of a background check and you don't find the part where they got cleared or whatever the case may be, and you use it as a reason to not hire or promote somebody, that's going to be a claim as well. So there's so many ways that you could come into an employment practices liability claim, even if they have, I guess, credit that's not as positive as you would like it to be. That can lead to things as well, like actual or alleged assault or battery or loss of consortium. If somebody loses their spouse in connection with something that was reported unfairly, that can be a wrongful handling of any background check. That can lead to an employment practices liability claim. It's just, you see what I said earlier about how it depends on how the attorney brings the claim. It really is unbelievable how far this can stretch. Third-party wrongful act means let's talk about what third-party wrongful acts are. It's really, again, I like the example I mentioned a while ago with the FedEx driver. He comes in and he brings the package or whatever, but he's constantly making inappropriate remarks or or saying something he shouldn't to one of your employees. And so that's a third party that's causing it, but that can cause an employment practices liability claim. I've actually had one in the past, and the claim was paid. But something being said that's misleading or misstated or an omission, it can lead to that claim, and defense costs go through the roof, even if there's no claim paid. Most of the time, it's the defense costs again that become the problem with these types of claims, just because the defense costs can be so much. Anybody got any questions? Third party EPL claim continued. Discrimination by any insurers against the third party in violation of one of those statutes or laws. Again, sexual or other harassment. It doesn't have to be sexual harassment, any harassment, bullying somebody, and just constantly, causing their life to be painful at work. That violates their civil rights. So, again, that's a federal statute that's going to come into play there, and it's going to create a third-party employment practices liability claim. Wrongful eviction or out of discrimination or harassment. You notice all this again says wrongful. It always has to be shown that it was in error or done intentionally and in a way that was directed against them. Any of that stuff can bring a third-party employment practices liability. And then company employment practices liability structure and the company structure. Okay, there's three types here. Employment practices liability for nonprofits. You see that all the time. If anybody's ever served on a board of directors or something like that, and I know I've served on a few, and basically one of the things I always tell somebody when they're asking me to serve is, I'm assuming you have directors and officers liability. For nonprofits, it's almost a given that they're always going to carry that, because it's hard to get somebody to serve on the board of directors if you can't insulate them from the liability. And that's what that policy would do. It would pay on behalf of those that are serving on the board of directors. I'm going to go to the other side now and talk about public company employment practices liability claims. And defense, let's go back to the first one then. Defense can be inside or outside the limits on nonprofits. On the employment practices claims for public companies, primarily defense is inside the limits. And what we're talking about here is defense costs. I told you those are the biggest piece of a lot of the claims, and they mount up quickly. We always want to be careful that the defense costs are outside the limits or there's an additional limit made available, because again, 60 to 70% of the claims that are seen are defense costs. So it can eat that limit up quickly. Let's say you got $600,000 cost for defense. That really basically, if you got a $1 million policy, only leaves you $400,000 for the actual settlement. So it's very important to make sure that on your employment practices liability policy that your defense are in addition to the limit, which is what I prefer, or outside the limit, either way, or have an additional limit. I said that backwards, but primarily I'm looking for outside the limit, which basically means there's no limit on the defense cost. Just it's provided in addition to the settlement. And this is the one that you guys are concerned about, EPL for private companies, because that's you. You guys are a private business, and this is really typically is something that's kind of overlooked a little bit for smaller private businesses. But employment practice claims can be, as we've talked about, broad number of things that lead to that problem and that claim. And so I think it's awesome that Right at Home has you guys to go ahead and carry employment practices liability, because it is such a huge number of claims that come with that. And so employment practices liability for private companies is a growing thing, and it's continuing to gain steam and momentum, but it's always been kind of way behind the nonprofits, if you will. Nonprofit employment practices liability has been almost a given for years and years and years. But I applaud Right at Home for requiring you guys to carry that because they're really helping you protect your business. Okay, let's go to slide 10. Are there any questions yet? Please let us know. On the policy structure, it's really pretty simple. You've got an insuring agreement A, and I'm not going to get too deep into this, but it covers the business, and that's what we also call the insurer. And insuring agreement B covers third party liability. You always want to have both. There are policies out there that just cover the business. We typically don't write any of those just because we feel like the third party liability has grown so much, and it's such a I don't know the exact statistics, but a large portion of the claims now come from third party liability. So if you look at your policy, you will see that there's two insuring agreements there, and you always want to make sure that the third party liability is there. On slide 11, it says, why buy employment practices liability coverage? Well, I know Right at Home requires you guys to carry it, but there's many other good reasons. It covers the defense with an EPL claim. Again, biggest part of the claims. Preventative measures encourages the organization to comply with employment-related regulations. And I'll tell you another reason. It's amazing how much help the insurance company gives you in controlling the cost of these claims and helping to make sure that you have policies and procedures in place going forward and even in the beginning to make sure that these claims don't occur. Of course, the big reason is financial protection. It protects your company's balance sheet, and that alone to me is plenty of reason. Again, I already alluded to this, but expertise and support, the risk management tools, the free advice from the company, insurance company lawyers, and the carrier's experienced legal team or pre-approved legal team. That's a huge piece of the benefit of having the employment practices liability. And here's the real reason at the end: mistakes, they happen. Who thinks they're perfect? Well, we all know we're wrong. We say we are. Has anybody got any questions at all? I don't see any at this time. I'll go ahead and put my contact information up here. Feel free to reach out to me at any time going forward. I'm happy to talk to you one-on-one, phone call, email, whatever. And happy to address your concerns about employment practices liability or any other insurance. Again, I'll take just another minute if anybody's got any questions. I know this is kind of a confusing topic. Seeing none, I will go ahead and thank you guys so much for your attendance. Thank you for your time today. And we look forward to the next webinar series that we bring to you guys. Have a great day.